Thank you.
SJC-11145, Tyler versus Michael Stewart.
Good morning, Your Honors. May it please the Court. My name is Jeff Carton of Meiselman, Denley, Packman, Carton, and Ebers. I'm joined by my colleague Greg Blankenship today, and together we represent the plaintiff Melissa Tyler and the class of Massachusetts residents she seeks to represent. Your Honors, Massachusetts residents have long enjoyed the protections of one of the strongest consumer rights set of laws in the country, laws which this Court has always ensured keep pace with transformations in society and developments in the way in which modern business is transacted. And I think it's only fitting that on the very day that citizens of the Commonwealth have an opportunity to cast their individual ballots to ensure and shape the political landscape of the future, this Court today has an opportunity to cast its collective ballot as to the scope and import of a statute which was enacted specifically to protect consumers' privacy rights in connection with commercial transactions.
Well, you say that.
Zip code? And you would say that applies even to zip codes?
I would, Your Honor, for any number of reasons. I think you have to first understand the remedial purpose for which this statute was enacted. And once we understand the remedial purpose for which the statute was enacted, it becomes plainly self-evident that zip codes would be included. It's the very issue with which the California Supreme Court wrestled last year in Pineda versus Williams and Sonoma.
Now, the California court, or at least as Judge Young sees it, saw a very different statutory history behind the California statute and as compared to ours. Do you agree with that?
I don't. I don't for the reason that, unfortunately, we don't have as developed a legislative history in this case as the California court had available to it. But when one looks at the language of the statute, the conclusion should nevertheless be the same. Let's look at the language of the statute, because I think, obviously, as Your Honors are aware, we're here, obviously, at the request of Judge Young and the parties because we're dealing with issues of first impression to which this Court has not previously addressed. And I think in order to understand the remedial purpose and scope of the statute, you have to look not only at the language of the statute, but you have to look at certain aspects of the statute in terms of how it's laid out. I think first you have to begin with the title of the statute. And the title of the statute is An Act Relative to Consumer Privacy in Commercial Transactions. Nowhere in the title of the statute did the general court denominate its intention to address privacy rights as it might pertain to identity fraud. And in fact, we can contrast the statute as we've done.
I mean, let's for a minute here. The statute doesn't protect a consumer from being asked information about their address, things of that sort, does it?
It does. The statute specifically prevents a retailer from requesting information from a consumer not required by the credit card issuer, and it provides including but not limited to, and it gives two examples, and I think those examples.
This is only when you've got a credit card transaction, right? I mean, there's
that is
nothing.
correct,
I mean,
Your Honor.
if you were somebody who paid in cash and they asked you for your zip code, which happens too, that's okay under the statute.
Well, I don't believe the statute addresses the statute specifically addresses credit card transactions.
Tell me where in the statute it prohibits a retailer from asking for identification in connection with a credit card transaction. I have to show my license all the time when I make a credit card transaction, or not all the time, but frequently, to confirm I'm the person on the card.
Identification purposes and recording personal
it
identification.
prohibits recording this identification on certain documents in connection with a transaction, not prohibiting the retailer from asking for that information.
No, the way in which the statute is written, Your Honor, it's to write or cause to be written personal identification information.
Right, so my personal information may have to be disclosed by the retailer if the retailer needs it, right?
Perhaps that
But it doesn't protect my personal information. It just protects a certain recording of that information.
Which in turn is protecting your privacy, Your Honor. If you look at the two examples in the statute.
But this is no general right of privacy. This is all focused on what happens with that information. Recording of it on a specific transaction document.
Correct. It does not go so broad as to create a general privacy right. Rather, it creates a limited privacy right in connection with a commercial transaction. And I think if you look at the two examples which are enumerated in the statute, your telephone number and your address, what do those two items have in common? They're both means of communication. Your Honor, they're both means by which a retailer can then in turn communicate in an unsolicited fashion with a consumer. Those examples do not speak to identity fraud. And I think if you contrast the legislature's statute regarding identity fraud, you have the perfect juxtaposition, because in Chapter 37E, it specifically talks about personal identifying information as constituting Social Security numbers or your mother's maiden name. If I give a retailer my mother's maiden name, that does not increase or enhance their ability to then communicate with me. It does perhaps allow them to assume my identity. Similarly, if you look at the scope of entities who are prohibited from collecting this information, in Chapter 105, it specifically refers to person, firm, partnership, corporation, or other business entity, unlike Chapter 37E, which only talks about the individual, talks about you. Why? Because partnerships, business entities, corporations can't assume my identity. A limited liability corporation, a partnership, can't walk into a retailer and say, I'm Mrs. Jones, I'd like to consummate this transaction. So again, when you look at the examples of telephone numbers and addresses, it's specifically to prevent the retailer's use of your personal identification information in connection with unsolicited communications.
All right, I go to gas stations from time to time, and I put my credit card in there, and it says zip code, and I punch my zip code in.
Very different scenario, Your Honor.
Okay, why is that?
Because that's specifically permitted to prevent fraud, and that information is not recorded. That's simply.
How do you know it's not recorded?
My understanding.
I type it in 0186. I won't tell you the last number. 0186.
My understanding of the industry, Your Honor, is that there is specific legislation that allows for gasoline retailers to collect that information.
That's federal legislation? It's not?
I'm not certain as to. But again, that's specifically for.
Why does that?
That's fraud upon the merchant, though. That's to prevent the unauthorized use of someone's card as against the merchants. That information, to my knowledge, is not recorded, and it's not then subsequently used for those gasoline companies' own independent marketing purposes.
Why would it matter?
Well, it would matter.
Get it? Why would it matter how they use it?
Well, because it would matter because there is both an inchoate right of privacy that consumers enjoy, and there's an economic value to our addresses.
The number has to be recorded somewhere because the number you're punching in has to match a recorded number, doesn't it? In order for the transaction to be validated.
I don't believe it's then recorded and kept by the gasoline retailer for their own marketing purposes in the way in which the Retailers Association, which would seek to come in as an amicus in this case, readily concedes that the identification information that's being collected by retailers in the Commonwealth is then being used for their marketing purposes, for their own business purposes.
Now, if the legislature were focused on that, why limit it to credit card transaction forms? Why not say it may not be written and kept in any corporate form?
Well, I think you have to look at the point in time at which the statute was enacted. It was enacted at a time the credit card transactions were predominantly in a paper form. It was the recording on a carbon copy. But the conclusion should be no different. If the remedial purpose of the statute is to prevent these unsolicited communications, to preserve the sanctity of one's home, some 45 years ago, Your Honors, Justice Berger, writing on behalf of the United States Supreme Court, remarked that a mailer's right to communicate must stop at the mailbox of an unreceptive addressee. The ancient concept that a man's home is his castle, into which not even the king may enter, has lost none of its vitality. And I would pose a hypothetical to Your Honors, which again is not the specific issue before you today, but which I think is telling in terms of the conclusion. Suppose Michaels or any retailer in the Commonwealth required as part of a credit card transaction the collection of your email address, and assume for the moment that that email address was not required by the credit card issuer. Would the conclusion that Section 105 has been violated be any different? It wouldn't. It would, in fact, be perhaps the simplest case to bring before Your Honors, because there the email address would naturally be personal identifying information. It would be an email address that would allow for an unsolicited communication, And at what point do we stop? We have to preserve the sanctity of a consumer's residence and their home, whether it's an unsolicited telephone call during dinner, whether it's an email, whether it's junk faxes, whether it's a knock on the door on the weekend. Enabling retailers to assemble this information through the collection of your zip code is exactly the evil.
Well, an email address might well fall within the definition of personal identification information.
And Justice Cordy,
An address. So in the electronic world, an address is an email address.
well, again, and I think
Personal to me. My zip code is not so personal to me. It's
Well-
personal to everyone in my town.
but in that regard, I think the reasoning of the Pineda Court last year in the California Supreme Court is instructive, because if we were to allow the components of an address to be accumulated but allow for a different result, we would effectively render the statute hollow. If I were to ask Justice Cordy for your address and you were allowed to give me your street name and your city, but you couldn't give me the house number, for all intents and purposes, I would now have the ability to have your home mailing address, much in the same way that Michaels takes the zip codes, uses a reverse database, and effectively constructs a mailing list. But that mailing list has value. That's the other challenge.
Okay.
Yeah, well,
Can we turn to the damages question?
I'd be happy to, Your Honor. The damages are twofold. The damages are the invasion of privacy that consumers suffer, which obviously under this Court's rationale, beginning
So
with...
without Liardi, where are you?
Well, I think Liardi, Aspinall, the Home Depot, there's any number of cases which obviously recognize the ability of a litigant to move forward with a non-pecuniary loss. So we have an invasion of privacy loss, which clearly would be sufficient to sustain a loss under Chapter 93A. Independent of that invasion of privacy, Your Honor, we also have the diminution in economic value to those consumers whose addresses have been given. We know that email addresses,
Wait, I don't get that one.
Sure. Mailing addresses, email addresses have value. Retailers pay for marketing lists, for
You mean,
databases.
So I've lost the ability to sell my address? Is that what you're saying?
I'm not suggesting that you've lost the ability to sell your address. What I'm saying
Worth
is
less because now Michaels has it?
you've been deprived the opportunity to assign economic value to it. And if for whatever reason...
Talk about abstractions.
Well, if for whatever reason, Justice Botford, moving forward in the district court, I'm unable to marshal sufficient proof to carry my burden to quantify that economic damage, that value,
Then you have the $25.
I have a statutory
And you have your
damage.
attorney's fees.
I have attorney's fees, yes, but I also have the statutory damages. It's no different than Justice Gantt's conclusion in this, I believe it was the CBS case, in which there was effectively a disgorgement of profits that a retailer was making when CVS was effectively making $1 per letter that it was selling on behalf of Merck. If those damages amount only to a nominal amount, then the statute provides for the recovery of statutory damages. Otherwise, we would effectively be rendering Chapter 105 a toothless remedy. And the general court is not in the business generally of passing legislation providing that a per se violation of that statute in turn be considered a violation of Chapter 93A, and then telling consumers that they have no resort to litigation. It also suggests the utility of a class action in this case. Now, obviously, we're not at that juncture in the district court yet, but I believe that when you look at the remedial purpose for which the statute was created, you look at the intent, you look at what constitutes personal identifying information, Judge Young, quite candidly, got it wrong. He simply took too narrow a view when he concluded that the statute was enacted only to prevent identity fraud, terms which are nowhere to be found in the statute, and terms which can easily be contrasted with the very statute which was enacted, both in terms of the entities to which it applies, as well as the types of information that were enumerated in the statute.
Yeah. If I can go back to this issue of the meaning of a credit card transaction form.
Yes.
If Michaels were to get the information if we're to basically say, okay, here's my credit card, take my address and phone number, put it not on a credit card transaction form, but put it in a separate document, which is customer list, would that be a violation of the statute?
I believe it would. I also believe it runs the risk of potentially elevating form over substance. What you have is obviously at the point of sale, and as consumers we've all experienced this.
Okay, so you're saying that the term credit card transaction form either has no meaning or should mean any corporate record?
No, not any record. I think it should mean the form that's created in connection with the transaction. And if at the time of transaction a cashier is inputting at the point of sale my address. Together, that's one integrated form. That's an integrated transaction. That's an integrated form. And to suggest that that information is then subsequently segregated into a different database, respectfully, Your Honor, I think elevates form over substance. Again,
I get a transaction form. I sign a transaction form. It doesn't have my zip code on it.
well, you don't know what's being maintained. Well,
In a different database. I mean, I get a transaction form.
you get a receipt.
Yeah, I sign it and they give it back to the dealer. And I assume that's the form that goes to the credit card company that gets a collection. My zip code isn't on that.
And sometimes, Your Honor, you do that at an electronic terminal, and you're simply handed a document which is the receipt. The credit card transaction form is the very form, again, in a digital electronic age, has to include all of the information that's being collected by the retailer at that moment in time. It's a single integrated transaction.
Counsel, your time is up.
Thank you. I very much appreciate the opportunity to have been heard on these issues. Thank you.
Good morning, Your Honors. Eric McDonough on behalf of Michael Stores. We began the discussion focusing specifically on the act itself, but it came with some incorrect verbiage. The Massachusetts language does not contain any request or require language within it. That's the California statute. This statute is focused strictly on writing. This is a consumer fraud statute. It's not a collection statute. We had a lot of argument in appellant's briefing. We heard a lot of argument this morning about collection. That's the California statute. The Pineda court was concerned with collection of zip code information, and there was a specific reason for that. And the statute is different. Yes,
Well, I guess what do you say, though, to the argument that if the whole focus is fraud, what is it about the name and address that's special? I guess I just don't see why it would be so limited, and why that would necessarily, if the statute allows you to ask personal information, I just don't see why it's not broader than just fraud, what you tie that to.
Well, if the Massachusetts legislature had intended it to be broader, it could have or would have had language similar to the California statute. And the California statute includes much broader language, for example, any personal information. It also contains language that says on the credit card form or otherwise.
But doesn't it say name and including but not limited to name and address?
Yes, the California statute does say
Doesn't
that.
ours as well?
Yes, it does.
I mean, aren't they identical in language in that respect?
In that particular respect,
Well, isn't that what we're talking about?
no, because if we look at language within the broader California statute, where they talk about specifically, the California statute talks about requesting or requiring providing the information and asking the cardholder to write any personal identification upon the credit card transaction form or otherwise. That's significantly broader than the limited scope of the Massachusetts Act, which is simply focused on writing specific information down on a form.
Well, what else would be included? I take it maybe your driver's license number?
Yeah, that could be, and we see in the legislative history the limited amount that we have before us is specifically talking about a teacher who had his driver's license number put down on a credit card
That's
form.
one comment from Brookline to I mean, you can't really count that as what's in.
Well, fair enough, but it is all we have. And the legislative history in California was significantly more developed, and it allowed the Pineda Court to go into much greater detail and address other significant concerns that perhaps were relevant to the California consumer.
Do we need the legislative history to understand what seems to be fairly clear language?
I actually don't believe that we do need the legislative history here. I think the language is so clear, and the language is specifically focused on writing on a written form specific information. I don't think we actually
And
need
here, it was written that the zip codes in question were written.
No, it's not alleged to have been written. For example,
Well, it was recorded in some fashion. Are you going to be, are you arguing that electronic recording
Isn't
of
writing?
information is not writing?
Yes. Yes.
That's your contention?
Yes, and if I could, specifically here, Ms. Tyler has not alleged that her information was recorded. At paragraph 6 of her complaint, she indicates that she provided that information, but she doesn't specifically say that it was recorded. Later in her complaint, she articulates that as a general practice, the information may be recorded, but she doesn't actually say that her information was recorded and asks the court to take specific note of that.
Now, in electronic transactions, which is what most credit card transactions are these days,
Yes, that's right, but not in
this statute
1991.
would in effect be useless.
This
because
particular statute, as written, would be useless now.
Yes.
Because with
You're saying,
respect
so this
to-
basically has no application to most transactions, that most credit card transactions that are taking place today?
Well, I would argue that that's correct, because this is focused on a specific thing. It's focused on consumer fraud and risk of that fraud if your personal identification information is on a written form that has credit card information. For example, in 1991, when this was passed, when a document is run for a transaction, it has your entire credit card number on there, and what happened to the teacher is another piece of information was written on that form, and apparently someone got a hold of that. So this is focused specifically on a written form, and in order to protect the consumer from having a piece of paper out there in the community that has not only his or her credit card information on it, but more personal information, you can reverse engineer and somehow come up with identity theft. So it's focused on
So your view is that the legislature did not anticipate the possibility of computer data also being stolen, as opposed to paper going astray?
Well, I'm not sure I would say that, Your Honor, because in 1991 it was kind of on the cusp of a lot of the electronic development of cash registers, the internet, and those sorts of things. So I wouldn't say they didn't consider it at all, but I think this statute is focused specifically on writing in a written form. So to the extent that they had it in mind, or they wanted to talk about electronic registers or electronic data, they could have updated it or they could have had it in here. So I think specifically with respect to this statute, I do believe it's focused solely on a form, a written form.
If the form statute says can't have address, correct?
The statute does specifically
All
say
right.
that you
And
cannot
what if the
write an
address includes the zip code? Do you say everything's wrong there except the zip code would be okay? If the merchant crossed out the address and just left the zip, I'm just trying to see why you don't consider the zip code part of the address?
Well, standing alone, it's not a problem with respect to this specific statute. The concern and what's been focused on in some of the papers is how it developed in the Pineda case. And what the California court was concerned about is, in California, it's a much broader statute, that you can't request or require this information, that they don't want the retailers to have any of the information. So the Pineda court looked and said, you're kind of making an end around to what the statute is saying. The statute's telling you you can't have this information, and you can't have it for a specific purpose, because the legislative history in California articulated clearly that it didn't want retailers to have this information so that it could reverse engineer. So that is particular as to California. We don't have that situation here.
But Judge Young, well, let's take that argument. I mean, Justice Cordy notes the gas station example. Zip codes are used by credit card companies to verify the risk of fraud. If you present a card number and you identify the zip code, that will improve your chances of having that transaction go through. So why is not a zip code important, even if the issue is identity fraud?
Well, the examples you're citing, I believe, are a gas station or a standalone kiosk or somewhere else.
I don't know where else that may matter, but there's no record right here. But the mere fact that it is used by credit card companies to verify does suggest that you're better off with a zip code and a credit card number than with the credit card number alone.
Sure, but that's generally used when there's not a face-to-face transaction. So confirming that you're using the card is generally at a gas station, as Justice Cordy has articulated, or a standalone kiosk or something along those lines where there's not a face-to-face.
Okay, and isn't that a risk of identity fraud? A telephone transaction, a kiosk transaction?
Well, not with respect to this particular statute, because it's not written anywhere. If you're just typing in numbers at a gas station pump, that's not written on a form.
Right, I'm not saying
information
the gas station is in violation, but I'm saying if the concern is that this information is going to be used by people who may get access to your credit card number to improve their chances of being able to use that credit card and impersonate you, I'm questioning whether or not the zip code is not something which would improve your ability to misuse that number.
Well, if I could step back briefly on that, if we look at the statute itself, it specifically excludes information that is required by the credit card companies. So if using your example, if...
Right, but you're missing my point. The point is not whether it's appropriate to ask, which it is as long as you don't write it, but your point is this is an identity fraud statute. I assume then the inference is if you have that information along with the credit card number, it'll make it easier for you to commit identity fraud. And if the credit card companies use zip code to verify that it is the true user, would a zip code not be something which could be used to accomplish identity fraud?
Under this statute, Your Honor, if a zip code is written on a form, I would acknowledge that it could potentially be a little easier for someone to perpetrate identity fraud on someone. And I think that's what this statute goes to. But again, this statute, if the credit card company does require one to submit his or her zip code information for the transaction itself, that would be carved out from this particular statute
Right, but
by its own very own language. Yes, Your Honor.
No, I was just going to say, all right, let's take the gas station again. So I use my Visa at the gas station. It requires that I put in my zip code. I use the Visa at the store. It doesn't require, the credit card doesn't require, apparently, my zip code. Is it because the credit card company is requiring the retailer to get the zip code? I mean, why is it different? Same card.
Well, because my understanding is because it's a face-to-face transaction issue, and there's some special legislation that's been passed in California subsequent to the Pineda decision, some emergency legislation to carve out the gas station pump example so people can continue to get gas.
In California? Or?
In California, but the same issue would apply here in Massachusetts, obviously, is it's not face-to-face. So in the store, you can do other things to confirm that that person has purchased, that the purchaser that's presenting you with the credit card is that person. You can look at their license. You can do any number of different things for that. At the pump or on a standalone kiosk or something along those lines, the same preventions or preventative measures are not in place for the retailer, and they're there to protect the consumer as well.
Well, why can't they use the PIN number? Like you do at a kiosk when you get money, a bank kiosk.
Most credit cards don't have PINs. That's a debit card issue. So if you use your debit card at the pump, at least how we do it in California, Your Honor.
Most credit cards don't have PINs?
Most credit cards do not have PINs, as I understand it. You can have a zip code, but you don't need to enter a PIN to use your Visa. You need to use your PIN to use your bank card, your debit card. So there are two different issues on that note. To the extent you want to use your debit card at a gas station or at a retail outlet or anything along those lines, you want to use a debit card, then you use your PIN. But if you want to use your credit card at a gas station, standalone kiosk, then you have to use a zip code to confirm that it's you that's using it.
If we can turn to the issue of damages, let's take your point that the focus is on identity fraud.
Yes, Your Honor.
And take your point that the writing down of a zip code may, to some extent, increase the risk of identity fraud. Why is not the increased risk of identity fraud sufficient to provide a cognizable injury that would fit within the meaning of injury under 93A?
First of all, we would argue that that issue is not in front of this court. It's not a certified question, and so we'd ask the court to take some guidance on that. But I certainly want to answer your question.
Well, the court does say, well, I mean, I know that this question 2 focuses on damages, but the court also says whatever useful I forget the language, but I'll take whatever guidance you choose to give me as to the statute.
Understood, and I think the court was looking for kind of the scope of that and what should it apply. Should it be a fraud statute or a privacy statute, or how does it work? Because that is very important in Judge Young's determination. Is it a privacy statute or fraud statute? So our take on that, and there was some give and take prior to the questions being certified, is what's supposed to be certified. But that being said, to answer your particular question, you're talking about something that's a hypothetical injury that may or may not occur in the future, and Hirschnow and its progeny and other cases that cite Hirschnow don't accept the notion of a hypothetical or a potential injury. It's
Well,
an
I mean,
actual
if you have X% risk of identity fraud, and if this now has increased that risk to some extent, is that not a cognizable injury? I mean, certainly in the medical malpractice area, if I have a 5% risk of dying from brain cancer and a doctor through malpractice increases that risk to 20%, still less than half, but I'm injured.
Yeah, it's, I think, a little bit different, a little bit apples and oranges here. I mean, the potential that perhaps at some point in the time you may have your identity stolen is a little bit too tangential under the authority in the state of Massachusetts to apply that to a damage claim in this instance.
So you're saying that this claim can only be brought by somebody who says, I have been a victim of identity fraud and I have been a victim as a result of this particular cause?
Yeah, that I'm a victim of identity fraud or identity theft, and it's based on me having provided personal information to that retailer whom I'm suing.
Which would be individual to that. So, I mean, pragmatically, if that's the case, nobody could ever afford to bring a claim.
Well, there are the statutory damages we've talked about, and I recognize they're somewhat nominal. They do come with attorney fee provision and things of that nature. But yes, I would agree with that, Your Honor.
Counsel, we have to leave it there. Thank you very much.